We'll hear from the appellant when you're ready.
May it please the court, I'm Jonathan Masters here on behalf of Tri-State Insurance. I'd like to reserve 5 minutes for rebuttal, if I may.
Yes.
Tri-State is requesting reversal of the lower court's misapplication of the motion to dismiss as it improperly applied the standard. A fair and proper reading of the complaint and the allegations which are set forth there clearly show that the gravamen of the claims surround the inspection, testing, maintenance, and repairs that were provided annually to the system once it was installed. Briefly, not much procedural history to discuss here, but briefly, this is a subrogation file that was filed after a substantial water loss. After the complaint was filed and served, seeking to recover the damages by my client for what was paid under its policy, a motion to dismiss was filed. The motion, in our view, Your Honor, the lower court did not properly apply the motion to dismiss standards. As this court is well aware, and long-standing law in this state is that must construe the complaint liberally. It's presumed all the factual allegations are true, and giving the plaintiffs the benefit of all reasonable doubt. Now, the lower court focused on the fact that the defendant in this case did install the sprinkler system in 1992. There's no dispute about that. But what they also did after that is they returned on an annual basis to provide maintenance inspections. In fact, the complaint even cites to federal standards on fire protection systems of what is required when these systems are inspected and tested and what's supposed to be included in the reports.
Let me back you up just a minute. You agree that they installed it, but also that they installed it incorrectly at the get-go.
I do not, and that is not an allegation within the complaint. Now, paragraph 7 does mention
improper sloping of the sprinkler system
in
that
paragraph.
caused water to pool.
I'm sorry.
Improper sloping in the sprinkler system that caused water to pool.
Exactly, and there's no allegation in that complaint as to when the sloping occurred. What our allegation is that at some point the sloping occurred and that it should have been detected in the annual inspections. What the sprinkler company is attempting to do is say, simply because we installed it, we have no responsibility for all these years and all these inspections that we undertake all the following years. Essentially, they're trying to use the statute of repose to claim immunity, and that sends a frightening standard, I believe, to others if they can simply do work, do an installation, and then sign separate and additional agreements to come back year after year after year and say, well, simply because we installed it back then, we don't have any liability now. I do not believe, respectfully, that's at all what the statute of repose was intended. And more to Judge Davis's opinion, the allegations in the complaint, there's at least 7 of them that all mention specifically the repair, maintenance, and I have beat that point to death, I know, in my brief and below. And I think a fair reading of this is that the gravamen of our claim, the gravamen of what we're looking for, and the importance of where we think this went wrong is in these inspections, regardless of what was done, done or could have been done, because East Tennessee undertook the responsibility to do these inspections and had a duty to perform those and a duty to report, and did not, in our view. Now, that's getting way beyond what I think even we need to get into under a motion to dismiss standard here, because I think the allegations are clearly. And of course, that was one of the points we made in our underlying brief, is that the cases, at least 3 of the cases cited under the statute of repose that are by the East Tennessee sprinklers, all involve summary judgment standards. I would even submit that the Counts case, the 4th case that they submitted, although it did come up on a motion to dismiss, and there's no discussion of what standard, but you'll see there were affidavits submitted. So I would submit that even under that case, there was additional outside of the pleadings types of documents that came in and that were provided. We believe the complaint clearly provides that we're, again, seeking the maintenance, repairs, inspections, and any repairs over the remaining years up until when this water loss occurred. And we think the same argument applies, of course, to our count 2 under the contract claim. And I have two things I would like to share with respect to the contract claim. First, I think the fact that the allegations, as I was saying, clearly establish what we're seeking. They had these contracts, they had these agreements to come back, and these weren't unspoken oral agreements, I might add. These were agreements that they came back and they undertook their responsibilities and duties and did it year after year after year, and our allegation is they did not do that correctly. Second, there's an issue that sort of crept into the appeal that was never even argued or at least not included in any motion underlying, and that is the issue under the 10.02 in the attachment of the contracts. That, as we know, any motion to dismiss under Civil Procedure Rule 702 must state with particularity what the grounds for any motion. The issue with respect to the contracts being attached to the complaint was never raised. In fact, that was the first time that I recall that coming up is at the oral argument below or on this motion itself. I made the point that I thought the motion to dismiss only related to the negligence claims and not the contract claims. And the judge pointed out that there were no contracts attached to the complaints, and apparently dismissed it, at least in part, based on that. I would submit that was never raised in any motion below, and it's not properly before the court.
I have two questions.
Yes, sir.
Okay. What about was there an actual contract for services, and also was there an annual payment for those services, or was that payment done at the beginning of the installation and that was it?
There were annual, it was separate contracts that go for each year, and there were separate payments for any particular, first for the inspection, for them just to come out and test and take a look, and then, of course, if there were any repairs that were recommended. Of course, unfortunately, we never got into that below because it was dismissed on a motion to dismiss. But yes, they were separate individual contracts year after year after year after year, and we certainly believe that those created a responsibility, and that those responsibilities were breached. Is there a second question? I'm sorry.
I think you
Did I address all that? Okay, thank you.
In one.
Your Honors, the complaint, in our view, more than meets the basic notice standards under the longstanding Tennessee court rules. We believe that we have more than articulated what our claims are and provided that notice. We believe that in at least 7 paragraphs, and specifically in the count 1 and count 2, which are paragraphs 21 and 24 of the complaint, that we more than satisfied the basic requirements that we would need to with respect to providing notice and articulating what our claim relates to. And of course, that is the annual inspections, maintenance, and repairs that continued from year on and year out. Accordingly, I'm sorry, I thought you had a question. Accordingly, we believe this case should be reversed and remanded and allowed to continue into at least discovery. That's all I have at this time.
Hear from the appellee.
Good afternoon to the court and opposing counsel. I'm Cole Wheeler of Wolf McLean, Bright Allen and Carpenter for the appellee, East Tennessee Sprinkler Company Incorporated of Johnson City. The subject motion to dismiss before the court on review today results from failure to state a claim upon which relief may be granted as established by the Tennessee Construction Statute of Repose under 28.3202 and case law from this court in Caldwell, the Tennessee Supreme Court in Chrisman, and the Sixth Circuit Court of Appeals in a case that came out during the pendency of this matter, Hinman. I'll devote most of my time today to the appellant's failure to state a claim upon which relief may be granted per the Tennessee Construction Statute of Repose. Of course, in Hall v. Habitat for Humanity, Rule 12.026 states that a motion challenges only the legal sufficiency of the complaint, not the strength of the plaintiff's proof or evidence. The trial court should grant a motion to dismiss only when it appears that the plaintiff can prove no set of facts in support of the claim that would entitle the plaintiff to relief. The Tennessee construction statute of repose under Tennessee Code Annotated 28.3202 serves as a bar to plaintiff's recovery. It states as follows: all actions to recover damages for any deficiency in the design, planning, supervision, observation of construction, or construction of an improvement to real property for injury to property, real or personal, arising out of any such deficiency, or for injury to the person, or for wrongful death arising out of any such deficiency, shall be brought against any person performing or furnishing the design, planning, supervision, observation of construction, construction of, or land surveying in connection with such improvement within 4 years after substantial completion of the improvement.
What about the provision in the complaint that says they should have been identified, the sloping, improper sloping should have been identified and detected during the services and inspection and maintenance?
Your Honor, as the trial court found in paragraphs 5 through 7, the plaintiff is a master of his complaint, and this complaint states that due to improper sloping in the sprinkler system that served as the proximate cause of the property damages occurring, that is arising out of any such deficiency in the design, planning, construction of such improvement to real property here.
Does the complaint, excuse me, does the complaint talk about the annual inspections?
Your Honor, the complaint does cite that there were inspections that did occur. However, by the complaint's own admission in paragraphs 5, 6, and 7, East Tennessee Sprinkler installed the sprinkler system in 1992.
I understand the install part, but does the complaint make any allegations that this problem should have been discovered in these later annual inspections?
In paragraph 8 of the complaint, the third sentence states the improper sloping could and should have been identified and detected during East Tennessee Sprinkler services, inspections, maintenance, and repairs to Camp HLA's system. However, as noted previously, such contracts were not attached to this complaint, and neither counsel or the court's interpretation of this complaint was as to those inspections being the cause or deficiency resulting in this loss. Moving to the Chrisman case, the Supreme Court of Tennessee held that in enacting the statute, the General Assembly intended to insulate contractors, architects, engineers, and others from liability for defective construction or design of improvements to realty where the injury happens more than 4 years after substantial completion of the Tennessee Code Annotated 28.3202, the construction statute of repose, is entirely unrelated to the accrual of any cause of action since it begins to run on the date of substantial completion as opposed to the date of injury or damage, citing Watts v. Putnam County. Turning again to paragraphs 5 through 8 of the complaint, paragraph 5 provides the date of substantial completion of this improvement to real property being 1992. Paragraph 6 provides the date on which damage accrued being October 7th of 2020. Paragraph 7 and into 8 addresses the alleged deficiency arising out of design or construction of that improvement being that the subject sprinkler system is designed as a dry system such that water should not remain in the lines. Paragraph 8 provides that due to improper sloping in the system, water was allowed to pool in the water lines. Again, the construction statute of repose states that all actions arising out of any such deficiency shall be brought against any person performing, furnishing, planning, or taking part in the construction within 4 years after substantial completion.
Yeah, but paragraph 5 does not say completion. It says since 1992.
And that is
Doesn't
correct.
that imply a continuous pattern all the way up to date?
So that is, the paragraph 5 provides that East Tennessee Sprinkler installed, inspected, repaired, and maintained the sprinkler system at Campus Chalet since 1992. Of course, that indicates that 1992 was the date of installation, and inspections and maintenance have continued since
But we
that
know that that's not the
1992.
case because it says since 1992. That means annually or however it's done, but all the way up to that period of time, doesn't it? 1992 is not the cutoff date.
So as far as inspection, repairs, and maintenance, that is correct. Certainly, the installation of the system has, the ongoing nature and the completion of that project, certainly 28 years later after the alleged October 7, 2020, there's no allegation in the complaint that this project has been ongoing for 28 years. It's that system was installed in 1992, and those ongoing inspections, repairs, and maintenance have occurred since
There
1992.
is an allegation in paragraph 9. It says it's never advised.
And that, Your Honor, that is stated in paragraph 9. Moving on to the plaintiff attempts to remedy this failure to comply with 28.3202 by citing to those alleged failures during inspection, testing, and maintenance. However, the statute is clear. Statute of repose is not revived by these future acts of maintenance. In Chrisman, the Supreme Court stated that the General Assembly intended to insulate contractors, architects, engineers, and others from liability for defective construction or design of improvements or realty where the injury happens more than 4 years after substantial completion of the improvement. In Hinman, which came out during the pendency of our motion to dismiss, the Sixth Circuit addressed 28.3202, the Tennessee Construction Statute of Repose, finding, to sum up, Tennessee courts have consistently looked beyond a plaintiff's characterization of a claim to determine whether, at its core, the claim falls within the plain language of the statute preventing all actions to recover damages for deficient construction, citing to Tennessee Code Annotated 28.3202. Decisions of the Tennessee Supreme Court strongly signal that contract actions can fall within the statute of repose, and that's from Hinman v. Valley Crest Landscaping Development, Inc. But for the alleged deficiencies in the design, planning, and construction in 1992 of this sprinkler system, there simply exists no alleged improper sloping, which served as a proximate cause of loss, as alleged by plaintiff, whether designated under an inspection, maintenance, testing contract, which again was not attached under Rule 10.03, or otherwise. The state Supreme Court addressed such attempts to avoid the statutory intent of Chrisman, stating, contractors are not at all insulated if plaintiffs are allowed to circumvent the statute of repose merely by sticking a different label on the claim. Additionally, as a secondary matter, the appellant has not raised nor objected to the trial court's award of attorney's fees pursuant to Tennessee Code Annotated 2012-119. So we would ask that that award be affirmed as it was not objected to. Further, the appellee moves for an award of additional attorney's fees pursuant to Tennessee Code Annotated 27-1-122 as this court in Caldwell, the Tennessee Supreme Court in Chrisman, and now the Sixth Circuit in Hinman have all ruled on this issue, which is applicable to this case. making this a frivolous appeal due to what the trial court saw as very clear existing precedent. Therefore, Appellee East Tennessee Sprinkler respectfully moves this court to affirm the trial court's grant of the motion to dismiss for failure to state a claim on which relief may be granted, as the state legislature intended to insulate against this very type claim where an owner of real estate had nearly 30 years of benefit from an improvement to construction and now attempts to come back against the installer of such improvements for what equates to a warranty claim.
Thank you. We'll hear from the appellant in rebuttal.
Thank you, Your Honors. Again, I believe, and reassert, of course, that the complaint clearly discusses the annual reports, annual testing, inspections, and so forth. I'd further submit the Cardwell, Cressman, the Hinman cases are inapplicable here. Cardwell and Cressman, of course, dealt with the design of drainage systems by a developer. There was no ongoing activity, no return year after year after year for anything, and that was not an allegation of those. In fact, the thrust of those two cases had to do with more, could a nuisance claim fall under the statute of repose. Hinman dealt with a pool construction and whether or not the construction of the pool later caused to whatever issues. But again, there was no ongoing return or to fix or repair those activities like we have here. Finally, we oppose attorney's fees because simply we don't believe the case should be dismissed. We believe we have appropriately made the allegations, and we indeed believe it should proceed forward, and we do, of course, have not only a hope of success, but believe we will be ultimately successful if we are allowed to proceed. Finally, this court should not allow East Tennessee here to use this statute of repose to hide and dodge responsibility for the years and of annual inspections and reports that it undertook all the way through and up till this event occurred and the damage happened. And that's all I have, Your Honors.
Thank you. Appreciate counsel's arguments in your briefs on this today. If you would, please recess court till tomorrow morning at 9:30.